Assalamu alaikum and welcome to the Free Legal Advice Show on British Muslim TV. I am your host, Rifat Hussain. Brothers and sisters, as you're aware, this is a programme presented to assist with your legal matters and allows you to engage with me by either calling me directly in the studio or by sending through your question in a written format on our WhatsApp group. Both of those telephone numbers to do that are found at the bottom of your screen. Just by way of guidance, if you are sending through a question, then please make sure you provide sufficient detail about the nature of your query. Try and provide some background information and details of what your question is, or even list your questions. That makes it easier for me to understand your query and give you a more tailored response to your question and guidance specific to you. If the question isn't clear, then I may only give some general guidance, but then that may not apply to your specific circumstances. You can ask a question in any category of English law. So you may wish to ask a question relating to employment law, for example, or family law. Immigration is a popular topic, so feel free to send your questions through as well. Do be patient with me. We do get a large volume of questions, and it's not always possible for me to get through all of your questions in a particular programme. If that's the case, then I will try and carry your question over to the following week and get through those questions, time permitting again. But feel free to submit your question if I haven't been able to answer it in previous weeks. Unfortunately, I can't address any questions relating to jurisdictions outside of England and Wales, and therefore may need to signpost you to other services. I have frequently been asked whether questions need to be in English. If you feel that you may express your question better in Urdu, then please feel free to send your question or speak to me live on air in Urdu, and I will be able to respond to that. I'm afraid my bilingual skills don't extend any further than that, so English and Urdu are the only two languages I can assist with, but feel free to send your questions through in either of those languages. I do have some questions on our group already, so I will proceed to those for you. So the first question I have relates to an immigration matter, UK immigration matter, in relation to an extension application for a spouse visa. The questioner asks that they are due to apply for an extension currently on a 10-year route to settlement under the partner category, and they are seeking to know what documents will be required to support that application. So a similar set of papers. The 10-year settlement route is usually granted to, particularly on the partner route, is to individuals who have entered the UK on a particular in a particular category of leave or visa, and have either then entered into a relationship in the UK and are unable to return, and it's unreasonable for that relationship to continue overseas. Alternatively, this category also applies for individuals who have entered the United Kingdom on a spouse visa, however, due to not being able to satisfy the immigration rules, have therefore been moved into the 10-year route to settlement, as opposed to an extension of their spouse visa and settlement through that particular route. The questioner is in one of those two categories. That leave is granted for a period of 2.5 years. There is then a need to apply for an extension. And this is where our brother or sister finds themselves and are wanting to know what documents will be required to support the application. The key thing is to show that the relationship is ongoing. Obviously, if there's a marriage, the Home Office is likely to already have a marriage certificate. If there was a subsisting relationship, then again, the Home Office is likely to have documentation from the previous application demonstrating that. But do provide updated evidence. The more holistic your evidence, the more evidence it encompasses, the easier it is for the decision maker to make that decision quickly and correctly. you don't want to rely on the Home Office going away and searching their files for previous documents. A, they may not do it, and the likelihood is that they won't do it. And secondly, they may miss something if they're relying on pieces of information that may have been provided in the past. So prepare a complete application. So again, provide evidence of the relationship. What relationship do you have? Are you cohabiting? And therefore provide evidence of cohabitation over a number of years. Or are you a married couple? And in that case, provide your marriage certificate. Any documents that are not in the English language will need to be translated officially and provided with the original to the Home Office. So that's another requirement. So marriage certificate along with any translation if that's necessary. Also in terms of continued subsistence of your relationship, because that's generally what the Home Office is interested in. It's not whether or not you are married on paper, but whether or not there is an intention and evidence to show that you are living together in that relationship as a husband and wife or as partners, and that relationship is ongoing and the intention is for that relationship to continue. The types of evidence you might want to show is evidence, for instance, of joint financial commitments, such as utility bills, if you have a joint mortgage, for example, or a joint tenancy agreement, anything like that really, joint bank statements, even individual bank statements where the bank statements are registered to the same address, letters from GPs, again, showing that you are registered at the same address. You may have additional evidence. You may have hospital appointment letters, for instance. You may even have other utility bills or other bills, for instance, mobile phone bills, anything official, council tax letters and bills. Those all go to support your claim that you are in a relationship, because generally people that are not in a subsisting relationship will not have joint financial commitments. Secondly, you may find yourself in a situation where you're living, for instance, with parents, and because it's your parents' property, generally everything else then follows to be in your parents' name or a family member's name. It doesn't have to be parents. So it may be that the mortgage or the tenancy is in family members' names, the utility bills are in family members' names, and there's very little that you have coming to your address. In those circumstances, you will need to think outside of the box. What other agencies can confirm that you are residing at that address? So, for instance, if you are in employment, and these can apply, even if you do have other sources of evidence, but if you are in employment, do your salary slips have your address on them? Do you have a contract of employment which shows your address? Are you able to get a letter, an updated letter? Your contract may be dated, for several years ago, for instance. Are you able to get an updated letter from your employer showing your registered address with them? Again, hospital letters, bank statements, these are individual to you. So even if you live in somebody else's property, they will still be addressed to you at your property. And in those circumstances, the best course of action is to take documents that are individually named for the applicant, so the husband or wife, and then to take documents that are addressed to the other partner, so the husband or wife, and then show that they are coming to the same address and therefore they are both living together at that address. You may want to consider taking statements or providing statements from family members, but also from other people within the community. Generally, if the evidence comes from family members or friends, then the Home Office attaches little weight to it because they can be self-serving. And therefore the Home Office may conclude, well, of course your family members are going to provide a letter because they want to assist you in staying in the United Kingdom. Where that letter is provided by other people that are maybe acquaintances or people that are not within your immediate family circle, then those documents can carry more weight, particularly if those people are hold a professional office. You may want to consider, for example, any teachers, if you have children, your children's teachers. You may want to consider ministers of religion. You may want to consider your work colleagues, for example. If you're involved in any kind of sports activities, any other community activities, there may be people within the community that can provide those letters. So there can be a broad range of evidence that can be provided to demonstrate that you are in a subsisting relationship. The 10-year route usually means that you are exempt from the financial requirement, but with the financial requirement, if you can demonstrate that you can meet the financial threshold of 18,600, then you may be able to vary your leave and come into the 5-year route to settlement. Although the 5 years would start again from the start, if, for example, you're only 2.5 years into a 10-year route to settlement, you still then save 2.5 years before you can achieve that settlement. So it may still be worth pursuing that. In addition, if you are going for the 5-year category, evidence of English language to the required standard, which would be B1, from an approved provider. Those kinds of documents will need to be in there as well. For finances, you've got salary slips, you've got bank statements. If you are self-employed, then you will need to show business accounts and also your statements from your accountant to show that those tax returns have been made, and your unique tax reference number. So there's a wide variety of documents there for you that you can start collecting and putting together. And the key thing again is make sure the application is submitted before the deadline. We are going to go to a short break now. Please do join me on the other side, where I will continue to answer your questions. Please do continue watching. Thank you very much. Assalamu alaikum and welcome back to the free legal advice show on British Muslim TV. I am your host, Rifat Hussain. Just before we went to our break, I was answering a question from our brother or sister with regards to an immigration application for an extension in the United Kingdom. I now move on to another question which has been presented by our brother. He asks, I'm a single dad of my 7-year-old daughter who is a British citizen, and I'm on the 10-year route visa on parents' route. I'm divorced by my wife and got married again in Pakistan and made an application for my wife to bring her into the UK. How much chance she got granted visa? How much chance does she have to be granted a visa because I've got limited leave to remain? So, brother, thank you very much for taking the time to send that question through. Now, under the immigration rules, in order to sponsor a spouse or partner from overseas, the individual, the sponsor in the UK, must have leave in one of the following categories. So they either must be a British citizen, or they must have indefinite leave to remain. That they may have settled status under the EU settlement scheme, or they may be a refugee. So you do not fulfill those categories. There isn't a category whereby you can apply for your spouse to join you as an individual with limited leave to remain. And so your question is, what are the chances of the application being successful? So in regards to the immigration rules, the chances are fairly low, simply because you don't meet the immigration rules. Generally, when an application is refused, you are then permitted a right of appeal, which you can exercise to the first-tier tribunal, the Immigration and Asylum Chamber. your wife will be given 28 days to exercise that right if in the eventuality that the application is refused. Now, appeal rights are on the basis of human rights, and therefore the right of appeal will not be in respect of the immigration rules not being followed. That right was taken away, or that ground of appeal was taken away several years ago. The ground of appeal will be that it would be a breach of your Article 8 human rights for your wife not to be granted entry into the United Kingdom. If you exercise that right and then ensure that you put evidence before an immigration judge as to how that family right would be breached. And bear in mind, brother, that it's not just your right that would then be breached. You also have a British child in the United Kingdom. You mentioned that you are a single parent, and so your child, your daughter, lives with you. And so there is a question about her human rights and what would happen to her if you were required to then travel to Pakistan and live there with your new wife. The reality of the situation may be in those circumstances that your 7-year-old daughter has to go with you. And the difficulty with that is, or the argument in respect of the law in there is that your British child would then be deprived of her rights as a British citizen if she is required to follow you to Pakistan. She's a child, she can't remain here by herself, and so she has no say over the situation. And so therefore deprivation of her access to her rights, such as healthcare and education, is a significant issue. Clearly the courts have accepted that, and they've granted you the 10-year route to settlement as a parent on the basis that it's unreasonable for your child to leave the United Kingdom. In fact, it would be unlawful to require your child to leave the United Kingdom. So although your initial application is likely to fail, you probably will succeed with a properly prepared appeal before an immigration tribunal. So the best of luck with that. I have another question, which I will then move on to. Assalamu alaikum. Alaikum assalam wa rahmatullah. Could you please give me a breakdown for calling my wife over from Pakistan when you're receiving carer's allowance and universal credit? So thank you so much for sending that question through. Again, an immigration question to sponsor a wife to the United Kingdom, and this brother is in receipt of carer's allowance and universal credit. Now, the universal credit, it doesn't really assist in any way here, but those who watch my program regularly will have heard me mention that the general financial requirement to sponsor a partner to the United Kingdom is that there is a gross annual income of 18,600. There are, however, exemptions to that, and that's certain public funds such as disability living allowance or personal independence payments, as they are more commonly known now, carer's allowance and various other disability-related benefits do provide an exemption and a different test. It's not that there is no financial requirement in those circumstances, it's just a different financial test. And in those circumstances, it's a sufficient maintenance test or adequate maintenance test that applies to these circumstances. And essentially what is meant by adequate maintenance is that upon paying your reasonable living expenses, so usually the Home Office will deduct housing costs, so rent or mortgage, council tax payments if you're not in receipt of benefits and are liable to pay those, major utility bills. So there's a list of major expenses, and after taking away those expenses, you are required to have disposable income, which is equivalent to income support levels. You can look those levels up on the internet. I don't unfortunately know them off the top of my head, but you would be looking to see how much you are required to be to have left over in terms of disposable income. And if you do have that amount left, then you have adequate maintenance. Bear in mind that you can take into consideration all of your income. So although it's the carer's allowance that exempts you from meeting the 18,600 threshold, you can then take into account your universal credit, your carer's allowance, and any other income and benefits that you may have to then show that you have the adequate maintenance. The best way to do this is to do a table of income and expenditure. So a table of income, a table of expenditure, and it depends on your circumstances as to what your expenditure might be. Again, going back to the scenario I gave prior to our break, if you are living with family members, for instance, and don't have housing costs, then your housing cost is zero. If you are living with family members and don't need to pay council tax, for example, or receive universal credit for your share of the council tax, then again that would be zero, or you would explain that it's zero to you because you are in receipt of council tax payments. And likewise with utility bills, generally people living with their family will either pay a small share towards utility bills or won't pay anything. So do an accurate reflection of your particular financial circumstances, total of your income, total of the expenditure, take away your expenditure from your income, and then take the total figure from there, and that will inform you as to whether or not you do have adequate maintenance. In terms of a full list of documents, which is what our brother has asked for, so again, you need to prove that there's a marriage, so a marriage certificate with a translation if it's not in English. You need to show that you've met each other. Generally, you can do that by providing 3, 4, 5 photographs. In terms of photographs, please don't provide a photograph in front of a white background with just you and your wife. That photograph could technically have been taken anywhere. It could be taken in your back room in the UK with a white sheet behind you. So generally, when selecting photographs where you're demonstrating that this is a genuine marriage, try and select photographs where there are other guests and wider family members in there as well. So just 2 or 3 to show that you're present. You may want to include your flight tickets to show that you have traveled to Pakistan or the location for the actual marriage. So any kind of evidence of the marriage. So you may have wedding invitations, etc. to submit there. You'll also need to provide information about your finances. So you will need to demonstrate that you have that you're in receipt of universal credit, but more importantly that you are in receipt of council tax, carer's allowance even. So a letter from DWP confirming that, and also one bank statement dated within the last 12-month period that shows that your carer's allowance is being paid into your account. In addition to that, your wife will need to demonstrate proficiency in English language to a very basic level of A1, but that does need to be completed with an approved provider. A TB test from Pakistan is also required. Again, bear in mind not to do that too soon. A lot of these certificates do have expiry dates, so your English language generally expires within 2 years. Your TB certificate only has a validity of 6 months. So be aware of when you are applying for these documents or going for these tests, because you don't want to do one too soon and then find that you're having to repeat it because it's expired before the application. You will need to show that there is a subsisting relationship, so evidence of how you're keeping in contact, and anything that demonstrates that there is a future intention for you to live together, and then evidence of adequate accommodation. And that generally means that you and your wife will have at least 1 bedroom for your exclusive use, so a private space for you and your wife when she resides in the UK. And if that is not your own property, then a letter from the person that you will be residing with to show that they are happy to accommodate both you and your wife. And what the arrangement is it rent-free? Will you be paying them rent? Is it short-term? Is it long-term? You may want a surveyor's report. A lot of the local estate agents do those, generally charge around £50, where they can come out and say, you know, the property has, for example, 4 bedrooms. They take dimensions and measurements, and they will also set out how many people live there to demonstrate that it is a habitable property and that there is sufficient space and a bedroom available for you and your wife. So generally that's the information that you need to provide. And do an online application with that. We are going to a short break now. Please do join me on the other side for some further questions. Thank you very much. Assalamu alaikum and welcome back to the Free Legal Advice Show on British Muslim TV. I am your host Rifat Hussain, and I will continue to answer any of your legal questions that you wish to present to me this evening. Brothers and sisters, thank you so very much for taking the time to send through more questions, and I do have many questions waiting, so I will proceed immediately to answering those. This is the penultimate segment of this show, so if you do have questions that you wish to send through, please do so that I can come around to those before this show ends. We have a question from our sister who sent this through our Facebook group. The sister asks, my son-in-law has been here for over 10 years and is married with 2 children and still hasn't heard anything, and he's not allowed to work either. So thank you so much for sending that question through, sister. I'm not entirely sure that I understand your question. It's not clear to me whether your son-in-law has made any applications, what applications, if he has, and how long he has been waiting for a decision. I mean, it seems rather unusual that he would be waiting for more than 10 years for a decision on any application. So if you could clarify that for me, that would be particularly helpful, so that I can provide you with more guidance. But that doesn't sound right to me, that your son-in-law has needed to wait for more than 10 years for a decision. It may be that there isn't an application pending for him. It may be that there's an application but it got lost in the system. It may be that he just needs to make a new application again. But if you could just set out some background for me as to what application has been made, what he's waiting for, and how long he's been waiting for that, then I can provide some further guidance. But thank you so much for taking the time to send that through. Inshallah, I will return to your question, but either please just call the studio and I'll speak to you live on air, or send a follow-up question for me so that I can just understand your situation a little bit better. We have another question. This question is from our brother. I am going to renew my wife's 2.5-year extension visa. She has now done the A2 test, and I need to know how many letters do I need to cover? To cover? Is it 6 months or 2.5 years? Thank you. So brother's renewing his wife's application, and he's wanting to know what documents he needs to submit with the application itself, and for what period. So the period generally is the 2.5 years. You are demonstrating that you have been in a subsisting relationship for that 2.5 period. So generally this is a probationary period that the Home Office grants to see if this relationship is going to continue, and if there is actually a true intention for this relationship to continue, so that individuals aren't applying for leave in this category and then the relationship breaks down, but they have been allowed to stay in the United Kingdom. So for 2.5 years, you don't need lots of correspondence covering the entire 2.5 years. Generally, 1 or 2 pieces for a 2 or 3 month period, just as long as it's consistent and that there's a clear pattern of a clear pattern that demonstrates that this is a subsisting relationship, and that, you know, it's not sporadic. You know, you don't get, for instance, a letter in January 2021 and then another one in August 2021, because there's too big a gap between those periods. So one letter a month, one letter every couple of months. Again, it depends on the quality of the evidence, and that's the key thing. It's the quality rather than the quantity. You know, the Home Office doesn't want to see 2.5 years of bank statements, for instance, or, you know, 2.5 years worth of Yorkshire Water bills, for instance. It's about the quality, and anything that demonstrates that this is a subsisting relationship and there is that intention to continue with that relationship. So I hope, brother, that does answer your question. But you are better off providing the evidence for the 2.5 years. If your question relates to the financial requirement, if you are meeting the financial requirement, for instance, then it is the 6 months. Then you do just only provide salary slips, for instance, for 6 months, bank statements for 6 months. You don't need to then go all the way back for the 2.5 years, but that's specific for the financial requirement. But for cohabitation, to show that you are in the same property and that this is a subsisting relationship, then as much evidence over the 2.5 year period would be of assistance to you. And best of luck with that application, inshallah. So they were the two questions that I wanted to go through at that point. We do have some more questions coming through here. So generally the theme this evening has been one of immigration law, but please do send questions through if you have a question related to another category of law, or if you feel that you are wanting immigration advice, then feel free to send through the question in relation to that. Just bear in mind, however, that with any category of law, but particularly with immigration law, the facts do matter. There are no two identical cases. There are no two cases where the same advice can apply. Each case has to be tailored to your particular circumstances. So there's some general advice that can be provided. For example, you know, the immigration rules require you to provide 6 months worth of pay slips if you are employed. You are required to provide, for instance, bank statements that you know, have the letterhead of the bank and are in a full letter format. That there are certain things that are prescribed by the immigration rules that must be done in that way. But with regards to how you effectively present your case with your individual circumstances will depend on your particular facts, and there will always be nuances to a particular case that don't apply to somebody else's, and that's why the detail is always key, and that's why specific advice to your circumstances is always key. The difficulty with immigration applications is that they can quickly put you into a cycle of refusal. So one refusal will lead to the next, to the next, to the next, and it's so difficult to unpick because there's always a record of the deficiency in the case previously, and sometimes it's difficult to explain away or to prove away that deficiency. And therefore, my advice always is please make sure the application is best prepared to ensure that there is a minimal chance of that refusal. And you can achieve that by, if you really do want to, preparing the application yourself, and then maybe going through an application check-in service just to have that second professional glance over your documents to make sure that you haven't missed anything, to make sure that all of the eventualities of your circumstances are covered fully, or even get the legal advice from the outset and ask someone who's experienced enough to prepare the application for you. But the guidance that we do provide, as long as you're following that through, you are providing as the full kind of background to your case, then generally the advice can be followed, and inshallah you will meet those requirements. So in terms of the next question, we have another question again asking about the documents in an immigration application. So usually the best place to start with these is that there is a section in the immigration rules that's called Appendix FM. And Appendix FM is where you will generally find the rules relating to spouse applications for partners coming from overseas, but also partner applications from within the UK. And the immigration rules no longer use the terminology spouse. They don't differentiate between married and unmarried partners. So it is just generally known as a partner category. And there are different categories within the immigration rules, depending on whether that application is made from within the United Kingdom or from outside of the United Kingdom. There is with Appendix FM another appendix, which is Appendix FM, and it has specified evidence with it. And that is a prescriptive description of the evidence that is essential and mandatory, and failure to provide that evidence in the format of the rules will generally result in a refusal of your application. Unfortunately, it's notoriously difficult to read. There is a lot of cross-referencing from one section to the next section. But if you do have the time and the inclination, then please do ensure that you do check those for the circumstances that apply to your case, and that you are ticking off, make a checklist, and that you are then ticking off the documents that you are required to provide, and just cross-reference to make sure that they are in the correct format within the correct date period, to make sure that you don't miss anything. That there is the appeal process to fall back on, but unfortunately the appeal process is not a cheap one, and it is time consuming. At the moment, appeals within these categories can take anything up to 18 months to even reach the tribunal. And then you've got the decision period as well. So they can be hugely expensive, hugely time consuming. And so even though the option is there, it's not really a position that you want to find yourself in. The best course of action is to ensure that the application is properly prepared and fully prepared from the outset to minimize any kind of refusals there. So thank you for sending those questions through. We have a question here in regards to the registration of children as British citizens. And this is a question asked by a sister in regards to the rights of her child, who's not a British citizen at the moment. However, she wants to know the options for registering her child as a British citizen now that she has status in the United Kingdom. With regards to that question, I will return to that after this break. Please do join us again so that I can address your queries. Thank you very much. Assalamu alaikum and welcome back to the final segment of the Free Legal Advice show on British Muslim TV. I am your host, Rifat Hussain. Just before we went to break, I was continuing to I wasn't asking the questions, I was answering the questions. You were asking the questions in relation to your legal matters, and I will continue to do that for this final segment. If you do have a question that you want me to answer this evening, please do send that through now, if you do want me to get around to it this evening, and I will try to get your answer before we finish for today. We do have a number of questions waiting. So the next question I have is in relation to, again, another immigration issue, and this time it's in relation to a child who has been in the United Kingdom. So the questioner asks that the family arrived in the United Kingdom about 8 years ago now. The child of the family was born in the United Kingdom, and I'm told that the child has not left the United Kingdom since their birth. Can we apply for a visa to stay in the UK? So generally with the immigration rules, there are provisions for children to apply if they have been in the United Kingdom for a period of 7 years. And so under the immigration rules, the Home Office will be required to look at the life of the child, and the Home Office is under a positive duty to promote the welfare of the child concerned. And what the Home Office will be considering is, well, firstly, has a child been in the UK for a period of 7 years? So evidence will need to be provided in respect of that. Now, bear in mind, it's easier to provide evidence once the child has gone to school, because you can show that there are school records, the school can provide records. It's a little bit more difficult to show the records for a younger child, for a baby. The kind of things that you may look at is your health worker records. It might be the Red Book, for instance. You may have doctor's letters that your baby will be registered with a GP. The problem is that unless you've gone to your GP regularly, all your GP letter will say essentially is that your child is registered. It doesn't necessarily demonstrate that your child has not left the United Kingdom. An absence of a passport, again, indicative of the fact that your child couldn't have left the United Kingdom. But again, it depends on how the Home Office interprets that information. Generally, it looks for positive information to show that there is a presence in the United Kingdom. But health visitor records, Red Book, if your baby was in nursery, you'll have your immunisation records, for instance, that there will still be evidence there that will demonstrate that your baby has been in the child now has been in the United Kingdom for a period of 7 years. And what the Home Office is generally looking for is, does your child have a private life in the UK? And to a certain degree, the law does accept that where a child has spent their formative years in the United Kingdom, then, and that's the life they know, then it would generally be unreasonable for that child to then be removed. The difficulty generally can be is for children, for example, who have very little social interaction outside of the family home. So if you have a very young child, so a 7-year-old child, for instance, who's only been at school for 3 or 4 years, and they spend the majority of their time, apart from this period at school, with you and your immediate family in your household, then sometimes the Home Office argument will be is, well, your child doesn't really know much different. The main thing that they know is your family unit. And yes, they do have a limited circle within school, but children are quite adaptable and they'll make a new circle of friends if they are removed to your country of nationality, particularly where then you've got immediate family. If the children are well acquainted with your immediate family or even extended family, because you've had regular contact by telephone. So there may be instances where, even though your child has been in the United Kingdom for 7 years, the Home Office may still seek to argue that it's still reasonable for your child to return to your country of origin. And it's a balancing act. These applications are always a balancing act, because the adults within this child's life have clearly committed wrong. They have entered the United Kingdom. They have deliberately overstayed, particularly if an individual has entered for a period of 6 months and they're still here 7, 8 years later, then there's a significant period of overstaying. And overstaying generally means that you have broken the law. You've broken the immigration rules. You've breached immigration laws. You have stayed in a country where you were illegally present because your permission expired a long time ago. And so it's really difficult to justify the actions of the parents or the adults within this relationship. Generally, with these cases, the argument is, well, that's not the child's fault. The child did not choose to be born into this family. The child did not know when it was born in this family that the parents were overstayers and illegal within the country, and therefore the ills of the parents should not be borne by the child. But the broader the child's experience, the wider their network of friends, their social network is, the easier it is to demonstrate that they have that they have a private life in the United Kingdom, which would be unreasonable to be disrupted by the Home Office, and it wouldn't be promoting the child's welfare if that was disrupted. So that's generally the argument. So usually that's how the child acquires status in the UK under the immigration rules. And then the status for the parents then follows. If the child's being granted status on the basis that it's unreasonable to remove the child, or will be granted status on that basis, then the child can't stay in the United Kingdom unless the family and the parents do so as well. But the Home Office can be quite critical of these cases, and the tribunals have been known to as well, because of the blatant disregard for the rules by the adults. And sometimes judges do find it difficult to try and accept that a family should be permitted to stay in the United Kingdom when they have had such blatant disregard for the laws of that land. And deliberately manipulated that situation to allow them to make the status. But again, relatively straightforward, as long as you're providing evidence that the child has been in the United Kingdom for that period of time, that, provide evidence that they are well settled here, how they are well integrated in the United Kingdom, if there are other activities that your child is involved with, if there are other for instance, activities that they partake, or if your child has any other difficulties, if your child has, for example, additional educational needs where they are receiving additional support in school which wouldn't be available to them if they went overseas. If, for example, your child is particularly excelling in their education or sports or any other activity, if your child, for instance, has any health issues that are, again, being treated in the United Kingdom and probably would not be treated overseas, these can all be relevant in terms of evidence to provide the Home Office as to why it would be unreasonable for your child to leave the United Kingdom, particularly when they have spent their formative years in the United Kingdom. There is case law about what formative years it means. Is it, age 0 to 7? And there is some case law that says that, less weight should be given to that age bracket, because certainly for the period of time that your child was a baby, they had no understanding of life in the United Kingdom apart from you and your presence. And it wouldn't make a difference to your child whether they were in your arms in the UK or in your arms in Pakistan or anywhere else in the world. So the argument is that, certainly from one perspective, that formative years cannot be 0 to 7. Of course, there is the concession from the Home Office that allows you to make that application. The other body of case law says that generally formative years are between the years ages 7 to 14. And so if you've got an older child, particularly if they've been here since birth, if they are 8, 9, 10, then you do have a stronger argument. But in terms of the application under the 7-year policy, as long as you're providing evidence that your child has been in the UK and that it would be unreasonable for them to leave, then it's a fairly straightforward application that you can put through to the Home Office, both for yourself and for your child. In regards to children that have been born in the UK and reached the age of 10 years, then you may wish to apply for them to be registered as British citizens, as opposed to applying for limited leave to remain under the 10-year route to settlement. So I hope that does address your question. I'm so sorry if I haven't got around to your question this evening. Please feel free to send that through to me again next week, and I will start with your questions. And my apologies again, we have swiftly run out of time. That does take us to the final parts of the show for this evening. I do finish by thanking all of our viewers for watching, and for the brothers and sisters who have taken the time this evening to send through their questions. Please don't shy away from sending through your questions. You do have a WhatsApp telephone number at the bottom of your screen. Type out your message. If you prefer not to speak to me live on air, it is preferable, if you can, to ring the landline number and speak to me. I can then ask you further questions to clarify your situation, and then to give you tailored advice in response to your query. I hope that the programme is of assistance to you. For the brothers and sisters who then take the time to give me some feedback, thank you very much for taking the time to do that, and it's always much appreciated. I'm sorry that I don't always get around to thanking you individually and personally. That's the end of the show for this evening. Join me next week. Thank you.